Legal News Deep Dive, February 25th, 2026. 1. Idaho Trustees Sale Notice filed in Bonner County, Foreclosure Analysis. Overview. On February 25th, 2026, a trustee's sale notice was published in Bonner County, Idaho, scheduling a non-judicial foreclosure auction for June 19, 2026. The notice, published in the Bonner County Daily Bee, lists the property at 1714 River Road, Clark Fork, Idaho, names the trustee. Lists the property at 1714 River Road, Clark Fork, Idaho, names the trustee, Pioneer Title Company of Ada County D/B/ a Pioneer Lender Trustee Services, and beneficiary, and states that the borrower's payments have been in default since June 2025. It cites Idaho Code Section 451506 as authority for the sale, which indicates that Idaho's statutory non-judicial foreclosure process is being followed. Idaho Code Section 451506, Non-Judicial Foreclosure Framework. Idaho primarily uses a non-judicial foreclosure system for deeds of trust, meaning lenders can foreclose without a court lawsuit if they adhere strictly to statutory requirements. Section 45 to 1506 of the Idaho Code lays out the step-by-step procedure and timeline for such foreclosures. Notice of default. The process begins when the borrower defaults on the loan. The trustee must record a notice of default in the county records and serve it on the borrower and other interested parties, like junior lien holders. This notice marks the formal start of foreclosure and triggers a grace period for the borrower. Right to cure. After the notice is recorded, Idaho law effectively provides the borrower about 115 days to cure the default by paying past due amounts, fees, and costs, and thus stop the foreclosure. This cure period is not explicitly labeled in the statute, but is derived from the timing requirements for the sale notice, which cannot be set sooner than 120 days after recording the default. Notice of trustee's sale. If the default isn't cured, the trustee prepares a notice of trustee's sale. The sale date must be scheduled at least 120 days after the notice of sale is recorded, giving a roughly 4-month lead time before the auction. The notice of sale contains key details: date, time, and place of the auction, property description, the parties, grantor/borrower, trustee, beneficiary/lender, the original loan details, and the nature of the default and amount due. Notification and publication. Idaho law mandates that the notice of sale be broadly publicized to ensure due process and public awareness. The trustee must send the notice by certified mail to the borrower and anyone with a legal interest at least 120 days before the sale date. Post the notice in a conspicuous place on the property itself. Publish the notice in a newspaper of general circulation in the county, e.g., the Bonner County Daily Bee, once a week for 4 consecutive weeks, with the final publication at least 30 days before the sale. This ensures the public is informed of the upcoming auction. Affidavits of compliance. At least 20 days before the auction, the trustee must record affidavits proving that all mailing, posting, and publishing steps were completed in accordance with the law. These affidavits create an official record that proper notice was given. Foreclosure auction. On the scheduled day and time, the trustee conducts a public auction, trustee's sale, at the location stated in the notice. The property is sold to the highest bidder for cash in order to satisfy the debt owed to the beneficiary, lender. Idaho law allows credit bids by the lender. The lender can bid up to the amount owed without needing cash. Trustee's deed and possession. After the sale, the trustee issues a trustee's deed to the successful bidder, conveying title to the property. Under Idaho law, the purchaser is entitled to take possession 10 days after the sale, by which time any occupants, including the former owner or tenants, must vacate, or they can be removed as tenants at sufferance. Notably, Idaho does not provide a post-sale redemption period for the borrower in non-judicial foreclosures. Redemption is available only in judicial foreclosures, which are less common in Idaho. Table. Key steps in Idaho's non-judicial foreclosure process. Idaho Code Section 45 to 1506. Step and timing. Requirements and actions. Key Idaho Code provisions. 1. Notice of default, Day 0. Record and serve notice of default to borrower and parties. Initiates foreclosure process and starts cure period. Section 45-1505-3, Section 45-1506-2, Record Notice. 2. Borrower's right to cure. 115-day window approximate for borrower to cure default by paying arrears and costs to stop foreclosure. Practice under Section 45 to 1506, timeframe inferred. 3. Notice of trustee's sale. If default not cured, schedule sale greater than or equal to 120 days out. Notice of sale must include date, time/place, property description, parties, default, amount due. Section 45-1506-4, Sale timing. Section 45-1506-3-4, Contents. 4. Notice distribution. Mail notice of sale to borrower and interested parties, certified mail, post notice on property, publish in newspaper for 4 consecutive weeks, last at least 30 days pre-sale. Section 45-1506-4A-D, Mailing, Posting, Publishing Requirements. 5. Affidavits of compliance. Record affidavits proving mailing, posting, and publication at least 20 days before sale date. Section 45-1506-7. 6. Trustee's sale, auction. Conduct public auction on scheduled date time. Sell property to highest bidder, often the lender via credit bid. Section 45-1506-5-6. 7. Trustee's deed and possession. Winning bidder receives trustee's deed. Borrower's rights terminated. No redemption period. Buyer can take possession 10 days after sale. Occupants become tenants at sufferance subject to eviction. Section 45-1506-11. Local procedures and public notice. Bonner County adheres to these state procedures. The Bonner County Daily Beast serves as the official newspaper for legal notices in that area, meaning foreclosure notices must run there as required by law. Additionally, the Idaho Newspaper Association provides an online portal for public notices statewide, improving transparency by making foreclosure notices accessible to the public at large. Trustees also often post notices at the county courthouse. By statute, all proof of notice, mailing certificates, sworn statements of posting and publishing need to be filed in the county records before the sale, establishing that every legal step was followed. Implications for homeowners. When a trustee's sale notice is filed, it is a clear warning that the property is on a countdown to foreclosure auction. The homeowner, borrower, typically has a few months to act. Reinstatement/cure. Idaho's process allows the borrower to reinstate the loan by curing the default up to about 115 days after the notice of default. This usually means paying all missed payments plus any late fees and costs to get the loan back in good standing. If the default is cured in time, the foreclosure is halted. Loss mitigation. Borrowers may also work with the lender to find alternatives like loan modification, repayment plans, or forbearance agreements to avoid the sale. These solutions can sometimes stop the foreclosure if both parties reach an agreement. Sale preparation. If no resolution is reached, the homeowner should prepare for the auction. They might consider selling the property on their own, a short sale if the home is worth less than the debt, or simply be prepared to vacate if the sale proceeds. Up until the moment of sale, Idaho borrowers can still redeem by paying the full amount owed, including principal, interest, fees, to halt the auction. Effects on tenants and occupants. In Idaho, once a property is sold at a trustee's sale, any occupants, including renters or even the former owner if they haven't already left, generally have 10 days to vacate before the buyer can take possession. After 10 days, holdover occupants are considered tenants at sufferance, meaning the new owner can pursue eviction. Tenants renting the property may have limited protections. Under state law, unlike some states, Idaho doesn't provide a longer occupancy or redemption period to tenants in a foreclosed property. The 10-day post-sale possession rule applies to all occupants. Federal Protecting Tenants at Foreclosure Act, PTFA when in effect. The PTFA, which has been periodically in effect through federal legislation, can provide most bona fide residential tenants up to 90 days notice before eviction, and even allow them to remain for the term of their lease, with some exceptions. As of 2018, the PTFA was made permanent, so it is in effect. It ensures tenants get a full 90 days notice if they are renting a foreclosed home. This federal protection can temporarily supersede the shorter 10-day state rule, but it only applies to tenants, not to former owners. Service Members Civil Relief Act, SCRA. Another federal law provides that if the borrower or an occupant is an active duty military member, a foreclosure or eviction might require a court order and can be stayed or adjusted by a court. The SCRA is designed to protect service members from losing their home while on duty without due process. Borrower defenses and remedies in foreclosure. Even in a non-judicial process, borrowers can raise legal defenses or take action to delay or invalidate the foreclosure if something was done wrong. Procedural challenges. Idaho's strict requirements mean if the lender or trustee fails to comply precisely with the notice and mailing rules of Section 45-1506, the foreclosure could be challenged. For example, if the notice was not mailed to the borrower, not posted on the property, or not published correctly, wrong dates, or insufficient time before sale, these defects can void the sale or at least delay it. Borrowers, often through attorneys, might seek an injunction to stop the sale on such grounds. Substantive defenses. Borrowers might claim the default isn't valid due to mistakes, e.g., the loan was not actually in default, payments were misapplied, or raise issues like lack of standing. Perhaps the foreclosing party can't prove it holds the loan note. Or assert violations of consumer protection laws, for instance, if the loan or servicing violated federal mortgage servicing rules or the terms of the deed of trust. While non-judicial foreclosure limits court involvement, a borrower can file a lawsuit to raise these issues. Bankruptcy. Automatic stay. Filing a petition in bankruptcy court, Chapter 7 liquidation or Chapter 13 reorganization, triggers an automatic stay that immediately halts foreclosure proceedings. Even a scheduled auction can't legally occur without bankruptcy court permission. In Chapter 13, a debtor might catch up on arrears over a 3 to 5 year payment plan, potentially saving the home. However, lenders can ask the bankruptcy court for relief from stay to continue foreclosure if the debtor isn't making payments or if there's no reasonable plan to cure the default. Loan modification or settlement. Up to the time of sale, borrowers and lenders can negotiate a loan modification, adjusting interest, term, or principal, a forbearance, temporary payment suspension, or other agreements to avoid foreclosure. Importantly, under federal rules, if a borrower has submitted a complete application for loss mitigation more than 37 days before a scheduled sale, the servicer typically cannot proceed with the sale until that review is complete. Seek legal aid. Borrowers often benefit from consulting housing counselors or legal aid attorneys who specialize in foreclosure defense. They can help explore options and ensure the lender follows all legal requirements. Purchasers at the trustee's sale and title issues. The buyer who wins at auction receives a trustee's deed that gives them title to the property. However, certain issues can affect the quality of this title. Title is subject to senior liens. The foreclosure of a deed of trust will wipe out junior liens, any mortgages or liens recorded after the deed of trust being foreclosed, but senior liens, earlier recorded obligations like a first mortgage, property taxes, or perhaps IRS liens remain attached. A foreclosure buyer must ensure that the deed of trust being foreclosed is indeed a first lien or be prepared to take the property subject to any higher priority liens. Defective sale process. If the borrower or other interested party later proves that the statutory process was not followed, e.g., improper notice as discussed above, a court could set aside the sale even after the deed was issued. This is a risk for buyers. They might temporarily own a property only to lose title if the foreclosure is invalidated. Bankruptcy complications. If the borrower filed bankruptcy before the auction and the automatic stay was in effect, the foreclosure sale might be void or voidable. A buyer who unknowingly purchased at an auction conducted in violation of a stay could lose the property. Quiet title actions, especially if there are any clouds, uncertainties, on title, such as questions about the chain of title, or if the foreclosing deed of trust had an error. The buyer may need to file a quiet title lawsuit to obtain a court order confirming their ownership and clearing any disputes. Also, buyers often purchase title insurance, but title insurers might require a quiet title action or additional documentation before fully insuring a foreclosure title. Possession and eviction. If the former owner or that person's tenants haven't vacated, the buyer may need to use the legal eviction process, which in Idaho could involve a relatively quick unlawful detainer action due to the occupant's tenant at sufferance status after 10 days. The new owner should also be mindful of the Protecting Tenants at Foreclosure Act for any bona fide tenants, as mentioned, to provide the required 90-day notice if applicable. Interaction with federal law. Federal laws can overlay on the Idaho foreclosure process in critical ways. Bankruptcy law. As noted, bankruptcy, a federal proceeding, can pause or discharge a foreclosure. A Chapter 13 bankruptcy is often used to prevent a foreclosure by restructuring debt and paying arrears over time. Lenders must navigate the bankruptcy court to continue foreclosure if the debtor files. Protecting Tenants at Foreclosure Act, PTFA. This federal law, originally enacted in 2009 and later made permanent, requires that most bona fide tenants, arm's-length rental, market rent, etc., in foreclosed properties get a 90-day eviction notice or be allowed to stay through their lease term, with some exceptions, like if a new owner will use the home as a primary residence. It does not prevent foreclosure, but affects post-sale eviction timing. Service Members Civil Relief Act, SCRA. As mentioned, if the homeowner is on active military duty, a lender must verify military status and, in many cases, get a court's permission before foreclosing, even non-judicially. This can delay or stop a foreclosure if the service member's duty materially affects their ability to meet the obligation. Federal consumer protection laws. Lenders and servicers must also comply with various federal regulations, like RESPA and the CFPB's mortgage servicing rules under Regulation X, which, for example, restrict dual tracking, pursuing foreclosure while the borrower is seeking a loan modification, and require certain notices to borrowers before foreclosure. Violation of these can be raised in court by borrowers to challenge foreclosures. Table. Key distinctions in foreclosure-related tenant protections. Protection. Scope and effect. Idaho law, tenants at sufferance. After 10 days post-sale, any holdover occupants, including former owner or tenants, can be evicted as tenants at sufferance, no long-term right to stay. Protecting Tenants at Foreclosure Act, PTFA. Federal law, in effect permanently since 2018, requiring 90 days notice to bona fide residential tenants after foreclosure before eviction can occur. Also allows tenants to remain for remainder of lease term unless a new owner will occupy as primary residence. Service Members Civil Relief Act, SCRA. Federal law protecting active duty military, foreclosure, even non-judicial, generally requires a court order if borrower is in military service, and courts can delay proceedings or adjust obligations. Violating the SCRA can invalidate a foreclosure sale. Practical guidance. Lenders and trustees must meticulously follow each step of Idaho Code Section 45 to 1506 to ensure a valid sale. They should document everything, mail receipts, affidavits of posting/publishing, to later prove compliance. Borrowers should not ignore a notice of default. Time is of the essence to seek a resolution. Consulting an attorney early can help in exploring defenses or negotiations. Buyers at auction should perform due diligence, check for any senior liens, confirm whether the statutory process was properly followed, ensure no active bankruptcy is in play, and consider title insurance and possibly a quiet title action for peace of mind. 2. U.S. Supreme Court rulings, February 24 to 25, 2026. Late February 2026 saw significant activity at the U.S. Supreme Court, including two major opinions clarifying points of federal jurisdiction and sovereign immunity, and related developments in removal procedure and death penalty litigation. A. Haines Celestial Group Incorporated v. Palmquist. Jurisdictional defect requires vacating judgment. Background: Texas parents, the Palmquists, sued Hain Celestial Group Incorporated, a Delaware corporation and baby food manufacturer, and Whole Foods Market Incorporated, a Texas-based company, in Texas state court, claiming their child was harmed by baby food containing heavy metals. The Palmquists' lawsuit alleged state law tort claims. Hain Celestial, seeking a federal forum, removed the case to federal court arguing diversity jurisdiction, contending that Whole Foods, the in-state co-defendant, was improperly joined just to destroy diversity. Normally, complete diversity is lacking if any defendant shares the plaintiff state. Here both Palmquists and Whole Foods were Texas citizens. Hain argued Whole Foods was not a proper defendant and should be disregarded. In federal court, the judge agreed with Hain, ruling that Whole Foods was improperly joined and dismissing Whole Foods from the case. The case then proceeded in federal court without Whole Foods, and ultimately a trial judgment was entered in Hain Celestial's favor. Hain won at trial. However, on appeal, the Fifth Circuit Court of Appeals found that dismissing Whole Foods was erroneous. Whole Foods was a properly joined defendant, meaning the case never satisfied diversity jurisdiction to begin with. As a result, the Fifth Circuit vacated the entire district court judgment and ordered the case remanded back to Texas state court. Hain Celestial appealed this outcome to the Supreme Court, arguing that even if a jurisdictional mistake was made, the final verdict should stand since the trial was already over, citing a prior case, Caterpillar Incorporated v. Lewis, where a premature removal was overlooked because the jurisdictional defect was cured before judgment. Supreme Court decision: the Supreme Court unanimously, 9-0, affirmed the Fifth Circuit. The court agreed that subject matter jurisdiction in federal court was lacking from the start and was never properly cured, so the only option was to vacate the federal judgment and send the case back to state court. Key points from the court's reasoning. Federal courts are courts of limited jurisdiction, and they cannot act without proper authority. Jurisdiction is assessed at the time of removal or filing. Here, complete diversity was absent at removal because the Palmquists TX sued a TX defendant, Whole Foods. The doctrine of improper joinder, fraudulent joinder, allows dismissal of a non-diverse defendant only if there is no plausible claim against that defendant. But the Fifth Circuit determined the claim against Whole Foods had merit, so the dismissal was wrong. Therefore, the presence of the Texas-based defendant lingered as a jurisdictional defect through trial and judgment. Caterpillar v. Lewis, 1996, a prior Supreme Court case, held that a procedural defect in removal was tolerable only because the non-diverse party in that case was dropped for legitimate reasons before trial, thus curing the jurisdiction issue ahead of the final judgment. In contrast, in Hain Celestial, the defect was never actually cured since the dismissal of the non-diverse party was improper. The court rejected Hain's suggestion that it could simply dismiss Whole Foods at this late stage under federal R. Civ. P. 21 to salvage jurisdiction. Doing so after final judgment would undermine the fundamental principle that the parties cannot consent to jurisdiction that doesn't exist, nor can a court create jurisdiction retroactively. The plaintiffs had the right to choose a forum by joining a local defendant, and that choice must be respected unless there was a valid reason to ignore the defendant's citizenship. Implications: this ruling sends a clear message that subject matter jurisdiction is paramount. A verdict reached in a case where the federal court lacked jurisdiction from the start must be wiped out, no matter how far along the case is or how much judicial resources were expended. It clarifies the limits of the Caterpillar exception, emphasizing it only applies when a jurisdictional defect is actually cured prior to final judgment, not in a case where the defect is erroneously overlooked. For litigants: forum selection and strategy. Plaintiffs can defeat federal diversity jurisdiction by including a local defendant as long as that defendant has a plausible connection to the claims. This decision reaffirms that tactic. If the joinder is legitimate, defendants can't manufacture jurisdiction by arguing improper joinder without a solid basis. Removal practice: defendants must be extra cautious when removing cases on a theory of improper, fraudulent joinder. If they remove and the federal court turns out not to have jurisdiction, even a favorable judgment will be thrown out. This effectively means a waste of time and resources, so the incentive is to be sure of jurisdiction or perhaps not remove in close cases. It might also deter overly aggressive removal strategies since a mistaken removal can backfire dramatically. Judicial efficiency versus jurisdiction. The Supreme Court acknowledged that while it's inefficient to redo a trial in state court, efficiency cannot trump the requirement of jurisdiction. This preserves the constitutional limits on federal judicial power. The U.S. Postal Service versus Conan, FTCA Postal Exception Block suit for intentional misdelivered mail. Case summary. In a closely divided decision, the Supreme Court ruled 5-4 that the U.S. Postal Service, USPS, retains sovereign immunity for claims arising from intentionally misdelivered or withheld mail, due to an exception in the Federal Tort Claims Act (FTCA). Facts. Levine Conan, a landlord in Texas, sued the USPS under the FCA, alleging postal employees intentionally failed to deliver her mail, purportedly causing her to miss important rent checks and other critical documents, resulting in financial losses. Normally, the FTCA waives sovereign immunity, allowing lawsuits for many torts by federal employees. However, 28 U.S.C. Section 2680, B, known as the Postal Matters Exception, precludes lawsuits against the U.S. for any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. The key question was whether this exception also covers intentional wrongdoing by postal workers, like deliberately hiding or destroying mail. The trial court dismissed Conan's case, saying the claim was barred by Section 2680(b), since it arose from mail delivery issues. The Fifth Circuit Court of Appeals reinstated the case, interpreting the statute's reference to negligent transmission to exclude intentional acts, thus allowing suits if misconduct was intentional rather than merely negligent. Supreme Court decision. The Supreme Court reversed the Fifth Circuit, with Justice Thomas writing for the 5-justice majority and Justice Sotomayor writing a dissent for the 4-justice minority. The majority held that the FTCA's postal exception does cover intentional mishandling of mail, shielding the government from such lawsuits. Key points. Text and historical usage. The majority took a textualist approach, examining the ordinary meaning of loss and miscarriage of mail in 1946 when the FTCA was enacted. They concluded that those terms broadly encompassed any failure of mail to reach its destination, whether by negligence or deliberate act. In other words, Congress intended to bar all lawsuits stemming from mail going awry, including intentional theft or misdelivery by Postal Service employees. Policy considerations. The court noted that allowing suits for intentional misdelivery could open the floodgates to litigation over routine mail problems, which Congress sought to avoid by creating the postal exception. The Postal Service processes billions of pieces of mail. Drawing a line between negligent and intentional mishandling would still drag the government into court frequently. By using broad terms like loss or miscarriage of mail, Congress opted for a bright-line rule to keep these issues out of court. Negligent versus intentional, the plaintiff argued, and the dissent agreed, that since Section 2680(b) explicitly mentions negligent transmission, it implies Congress didn't mean to immunize intentional wrongdoing. The majority, however, reasoned that negligent transmission in the statute is just one type of postal problem listed, and it doesn't limit the scope of loss or miscarriage, which are unqualified and thus include all types of mail disruptions. They effectively read negligent as covering one category and loss or miscarriage as covering other scenarios, including intentional acts. Dissent's view. Justice Sotomayor's dissent criticized the majority for overextending sovereign immunity beyond what Congress explicitly provided. The dissent would have allowed suits in cases of egregious intentional misconduct, arguing that it's unlikely Congress meant to give the Postal Service a free pass to deliberately interfere with mail. She pointed out that the FTCA generally distinguishes between negligent and intentional torts in other provisions, and when Congress wanted to immunize intentional conduct, it said so. The dissent warned that under the majority's reading, Even deliberate theft or destruction of mail by a rogue postal worker would leave victims with no legal remedy, an outcome they found inconsistent with the FTCA's purpose. Implications: this ruling closes the door on any FTCA claims relating to mail delivery issues, strengthening the Postal Service's immunity. Claims barred: if a person's mail is lost, delivered to the wrong address, or even intentionally withheld or destroyed by a postal employee, they cannot sue the USPS for damages under the FTCA. Essentially, the government has not consented to be sued for anything that happens to your mail in transit. Accountability and alternatives: with this decision, those harmed by intentional mail tampering by postal workers have very limited options. They might seek redress through internal USPS complaint processes or ask for criminal investigations if theft is involved, but civil tort damages are off the table. This may raise concerns about holding the Postal Service accountable for misconduct. However, it aligns with the desire to prevent legal claims from interfering with postal operations. Clarification of law: the decision resolves a split among appeals courts. Some had allowed suits for intentional misdelivery, others had not. Nationwide, it's now clear that the postal exception is broad. Legal advisors will note that the scope of sovereign immunity under the FTCA is interpreted robustly by the court's majority, even in cases of intentional wrongdoing by government actors, unless Congress explicitly carves out an exception. No impact on Congress's ability to change law. While the court's decision rests on statutory interpretation, if Congress disagrees with this outcome, it could theoretically amend the FTCA to permit certain mail-related claims. Until then, however, USPS is immune from these suits. Table: Key Supreme Court decisions, February 24th to 25th, 2026. Case and issue. Supreme Court ruling. Vote. Significance: Haynes Celestial Group v. Palmquist, removal jurisdiction. Vacated federal judgment due to lack of jurisdiction. Removal was improper since a non-diverse defendant was validly joined. The error wasn't cured before trial, so the case returns to state court. 9-0 unanimous. Reinforces strict limits on federal jurisdiction, no fixing a case that was improperly removed after a final verdict. Defendants must ensure subject matter jurisdiction or risk wasted trials. USPS v. Conan, FTCA postal exception. FTCA postal immunity applies to intentional misdelivery. The USPS cannot be sued for claims arising out of the loss, miscarriage, or negligent transmission of postal matter, even if misconduct was deliberate. The plaintiff's case for intentional mishandling of mail is barred. 5-4, Thomas for majority, Sotomayor dissenting. Broad sovereign immunity for mail delivery issues. Victims of even deliberate mail tampering by USPS employees have no FTCA remedy, resolves a circuit split, favoring government immunity. See other notable Supreme Court developments. Debate on removal deadlines. Enbridge Energy, LPV, Nestle. On February 24, 2026, the Supreme Court heard oral arguments in a case about federal removal procedure deadlines. At issue is whether the strict 30-day limit for a defendant to file for removal from state court under 28 U.S.C. Section 1446 B can ever be tolled or extended due to exceptional circumstances. The case involves Enbridge Energy and a dispute with Michigan officials, led by AG Dana Nessel, over the Line 5 oil pipeline. Enbridge missed the usual 30-day window to remove the case and argues that extenuating circumstances justify a late removal to federal court. The outcome, decision pending as of February 25, 2026, will determine if federal courts have any leeway to forgive a missed removal deadline. This has broad implications for litigation strategy. A ruling either way will clarify whether that 30-day clock is inflexible or subject to equitable exceptions. Lower courts are currently split on the issue, so practitioners are watching closely. Execution Protocol Challenge. Trotter v. Florida. In a death penalty development, the Supreme Court on February 24, 2026, denied a stay of execution for Melvin Trotter, a Florida death row inmate. Trotter had sought to postpone his execution by arguing that Florida's lethal injection procedure risked a cruel and unusual punishment, claiming the state might use expired drugs and lacked transparency in its execution process. A majority of the court was unpersuaded that Trotter met the high bar for a stay, which requires showing a substantial risk of severe pain and proposing a readily available alternative method of execution under Bays v. Rees and Glossop v. Gross. Justice Sotomayor wrote a statement respecting the denial, in which she raised concerns about the state's secrecy and record-keeping around execution drugs, but ultimately the execution was allowed to proceed. This reflects the court's recent trend of being reluctant to grant stays of execution absent clear evidence of unconstitutional risk, and it underscores ongoing tensions over the transparency and humaneness of lethal injection protocols. 3. Philippines Labor Advisory No. 01, 2026, February 25th as a special working day. Context and background. In the Philippines, February 25th, 2026, marks the 40th anniversary of the EDSA People Power Revolution, a historic national event. While this date had been a special non-working holiday in some past years, Proclamation No. 1006, Series of 2025, declared that February 25th, 2026 would be a special working day. In response, the Department of Labor and Employment, DOL, issued Labor Advisory No. 01, Series of 2026, to clarify how employees should be compensated on that day. Meaning of special working day under Philippine labor law. Holidays are categorized as regular holidays, e.g., Bonifacio Day, Independence Day. These are days of national observance where employees typically have the day off with pay. If employees do not work on a regular holiday, they are still entitled to 100% of their daily wage. If they do work, they must be paid 200%, double pay for the day, and additional overtime pay, usually 30% more for hours beyond 8. Special non-working days, e.g., All Souls' Day, perhaps Chinese New Year, as declared by specific proclamations. On these days, the general principle is no work, no pay. If an employee takes the day off, the employer isn't required to pay, absent a more favorable company policy or collective bargaining agreement. If the employee works on a special non-working day, they're entitled to 130% of their regular daily wage, i.e., a 30% premium for the first 8 hours, and 130% of their hourly rate on top of the usual overtime rate for extra hours, effectively 169% of normal hourly rate for OT. Special working days. These are days that are nominally commemorative but considered regular working days in terms of pay. The key example is February 25th, 2026 in this instance. On such days, no additional pay premium is required by law. If an employee doesn't work on a special working day, the no work, no pay principle applies again, unless a contract or CBA provides otherwise. If the employee does work, they receive only their normal 100% daily wage for up to 8 hours, and overtime is paid at the standard 125% overtime rate, i.e., time and a quarter, for any hours beyond 8. In short, February 25th, 2026 is treated like a typical workday for compensation purposes. Labor Advisory No. 01, 2026. Key points. The DOL's advisory was issued to ensure employers correctly implement the pay rules on February 25th, 2026. It reiterates that February 25th is a special working day, by virtue of Proclamation 1006, which means there is no automatic day off. No work, no pay. If employees choose not to work on that day, or if the business is closed for the day, employers are not obliged to pay them for the day, unless there's a company policy or collective bargaining agreement, CBA, providing payment on special days. Work on February 25th. Regular pay. Employees who do work on February 25th, 2026 are entitled to their normal wage for the day. For the first 8 hours of work, they get 100% of their daily wage, no holiday premium. This contrasts with, say, a regular holiday where they would get 200%. Overtime pay. If employees work overtime on that day, beyond 8 hours, they receive an additional 25% of their hourly wage for the overtime hours, which is the standard 125% overtime rate applied to normal working days. No special premiums. The advisory makes clear that the usual premiums for holidays, like 30% extra for special non-working day or double pay for regular holiday, do not apply on a special working day. So, February 25th is compensated just like any ordinary workday. Employer and employee obligations. For employers, compliance with this advisory means treating February 25th as a normal workday in terms of scheduling. Offices and businesses can operate freely on this day. It's not a mandated shutdown day. Ensuring that payroll calculations are correct. For example, if employees work that day, they get their normal day's wage and appropriate overtime if applicable, but no holiday premium. If they don't work, the day is generally unpaid, unless an employer voluntarily provides a benefit. Communicating clearly with employees about attendance expectations and compensation rules for that day. Given that some might assume February 25th is a holiday due to its historical significance, companies should inform staff that it is a working day and clarify how leave or absences will be handled, likely as a normal absence or leave day. Checking any applicable collective bargaining agreements or company policies. Some employers might have agreements that treat certain commemorative days as paid days off or provide extra pay as a perk. The advisory allows such arrangements to continue if they are more favorable to employees than the legal minimum. For employees, understand that February 25th is not a free holiday in 2026. If you don't go to work, you'll likely need to use leave or else not be paid for the day, again, unless your company offers holiday leave for that day. If you do work on February 25th, expect your normal wage and the usual overtime if you work extra hours. Don't expect the 30% additional pay that a special non-working holiday would provide, nor the double pay of a regular holiday. Check your company's policy or CBA. Some employers might still choose to observe the day or offer additional pay or time off, but that would be a voluntary benefit. Philippine holiday pay context. The Philippines is known for having a complex holiday policy framework with different categories of holidays. The concept of a special working day effectively means the day is a regular working day under the Labor Code. It is a day of commemoration without the paid day off. This approach gives the government flexibility to honor certain events, like the People Power Revolution anniversary, symbolically, without the economic cost of a non-working holiday, which can be significant in terms of lost productivity. Regular holidays versus special days. The Philippines distinguishes between regular and special holidays in terms of pay obligations, whereas many other countries have a simpler dichotomy, holiday or not. For example, in the United States, there is no federal law requiring private employers to give paid holidays or extra pay on holidays. It's largely up to employer policy or union contracts. In the UK, public holidays, bank holidays, are generally treated as paid days off, but there's no statutory requirement for extra pay if employees do work. Employers can count bank holidays as part of the minimum annual leave entitlement required by law. Countries in the EU often have laws mandating a certain number of paid public holidays or premium pay for working those days, but the details vary. The Philippines' three-tier holiday system. Regular, special non-working, special working is somewhat unique in how it differentiates levels of compensation and obligation on different types of holidays. Table: holiday types and pay in the Philippines versus selected countries. Country. Holiday type. Work/pay requirements. Philippines. Regular holiday. No work, paid 100% daily wage. Work, 200% wage for first 8 hours, double pay, plus 30% hourly rate for overtime. Philippines. Special non-working day. No work, no pay unless company policy/CBA says otherwise. Work, 130% wage for first 8 hours, plus 30% on top of OT rate for extra hours, effectively 169% for OT. Philippines. Special working day. No work, no pay unless policy/CBA says otherwise. Work, 100% regular wage for first 8 hours, no premium. Overtime at 125% of hourly rate, normal OT rate. United States. Federal holiday. Federal law does not mandate private sector paid holidays or premiums. It's up to employers. Federal government workers do get paid holidays by policy. United Kingdom. Bank holidays. 28 days of paid annual leave is required, often including 8 bank holidays. No extra pay mandated if one works on a holiday. It depends on employment contracts. Table note: many countries have laws or labor agreements that provide for premium pay, time and a half or double time, on certain holidays or Sundays, but practices vary widely. The Philippines' special working day is essentially treated as a normal workday, unlike its 2 other holiday types that do have statutory benefits for workers. Practical compliance for February 25, 2026. Philippines employers should update their payroll systems to ensure no holiday premium is applied on that date, and communicate clearly with employees that work on February 25th will be compensated as usual. Any specific company provisions in employment contracts or CBAs that are more generous, such as offering extra pay or allowing leave on that day, should be honored if they exist. Employees should plan their work and leave considering that February 25th is a regular working day and not assume they will automatically have the day off or receive bonus pay. Conclusion. In summary, the legal developments of February 25th, 2026 span vastly different areas, but each carries significant implications. In Idaho's real estate law, the filing of a trustee's sale notice in Bonner County underscores how strictly non-judicial foreclosure procedures are structured under Idaho Code Section 45-1506. Homeowners in default face a quick timeline from default to auction, as little as 4 months, but also have opportunities to cure or mitigate the default. The process demands precision in providing notice to protect borrowers' rights, while balancing the lender's ability to recover the debt. Post-sale, property rights swiftly transfer to buyers after 10 days, though federal laws like the PTFA and SCRA can provide additional protections for renters and military personnel. Both borrowers and bidders must be vigilant, borrowers to assert their rights and explore alternatives, and bidders to ensure the sale is legally sound and the property's title is clear. In U.S. Supreme Court news, recent decisions have clarified important points of law. The unanimous Haynes Celestial v. Palmquist ruling cements the principle that a defect in federal jurisdiction is fatal unless cured before judgment. A win for plaintiffs' choice of forum and a caution to defendants considering removal on shaky grounds. Meanwhile, the divided ruling in USPS v. Conan expands the postal immunity under the FTCA to encompass even intentional misconduct by postal workers, highlighting the court's current inclination to read sovereign immunity protections broadly, much to the dissent's concern about leaving victims without recourse. Additionally, the court signaled interest in clarifying procedural rules, as in the Enbridge removal deadline case, and continued its pattern of wariness in last-minute death penalty interventions, as seen in the denial of Melvin Trotter's stay. In Philippine labor law, February 25, 2026 was designated a special working day by the government. Dole's Labor Advisory No. 01/2026 ensures that employers and employees understand that this day, despite its historical significance, is not a regular holiday for wage purposes. Work done on that day is paid at ordinary rates, with normal overtime rules, and those who don't work generally receive no pay. This classification reflects a nuanced approach to balancing commemoration with economic productivity. By comparison, many other countries either treat such observances as regular holidays, with time off or premium pay, or have no special designation at all, making the Philippine system unique in its complexity. Both employers and workers in the Philippines should adjust their expectations and payroll practices accordingly for special working days to ensure legal compliance and proper compensation. Disclaimer: this report is for general informational purposes and does not constitute legal advice. Laws and court decisions are summarized for clarity and brevity. Always consult the actual statutes or court opinions and a qualified attorney for legal advice on specific issues. AI-generated content may be incorrect.